Hi, I'm attorney Gregory Dell here with attorney Cesar Gavidia, and we're going to talk about New York Life long-term disability insurance lawsuits. Now, Cesar, you know that in December of 2019, New York Life purchased the Cigna Group and Life Disability Insurance Division for approximately $6.3 billion. And while that was a surprise to a lot of people because New York Life was, yes, they had a group disability coverage that they sold, but it was really more to associations and groups like, for example, the American Bar Association, where they were basically policies that were exempt from ERISA. So they were more in line with the individual disability insurance policies that resulted in what were your traditional lawsuits that most people think of, where you get a jury trial. Now that New York Life has taken over for Cigna, they have obtained one of the top three largest true group disability insurance carriers in the country. And I know New York Life, being one of the biggest insurance companies in the world already, part of their business model was, we are going to expand into the whole true group world of disability coverage. Well, what we believe is going to happen, and really hasn't fully transitioned yet as we do this video in September of 2020, is that the Cigna people, from what we see from press releases, are going to continue to manage the block of business for New York Life. So we've been handling for more than 20 plus years the Cigna ERISA disability lawsuits and have literally filed hundreds, if not thousands, of lawsuits against Cigna. However, everything's going to change now to lawsuits against New York Life. And a lot of people who had these policies are either going to stay in the name of Cigna or possibly get them changed to New York Life. But you know that creates issues because in certain states, they don't want to reissue policies because of the discretionary clause laws that once a policy is reissued, that if a policy was before a new discretionary clause law was out, when it comes after, then the discretionary law applies. And we'll touch on that in this video, because in this video, we want to talk about the expectations for a person who has had their long-term disability claim denied by New York Life, and now they filed their appeal, and the only remedy is to file a lawsuit. So getting right into it, Cesar, one of the biggest questions we get right out of the bat is, look, I've been denied. How long is this going to take, either to get a settlement or to go through a lawsuit?
So before even getting to that part of the claim or case, the point where we're filing a federal lawsuit, you said we'd have to go through some administrative appeals, and that's pretty common in both group disability cases that are not necessarily governed by ERISA, and of course in the employee benefit ERISA context. So typically, they'll tell you and provide all of those deadlines within their appeal, within the denial letter that you're provided. It's one of the things under ERISA that they're required to do. So New York Life has to give you all of those time frames. Okay, we've denied you. If you wish to challenge this decision, you have to appeal this decision within 180 days. Okay, so within 6 months, you've got to provide us with all of the information and all the reasons why we're not right, we're not correct in our decision to deny your claim for benefits. They would then have typically about 45 days to review that appeal material. They could seek additional extensions, usually an additional extension of another 45 days, kind of totaling it up to 90 days. And of course, all the while, you are waiting for them to make a decision and waiting on your benefits to roll in. You could continue providing them information and evidence and documentation and medical records, which we always recommend that you do through that time period, because that's important. That continuity of disability is really important. If they deny your appeal, then you usually, as long as there's not another level of appeal that you're required to exercise or go through, with the same types of deadlines, 180 days, then they have 45 days, and then possibly an additional 45 days to make a decision, and additional extensions if they reach out to a doctor or waiting on information or waiting on a report or waiting on a record to come in from you. At that point, you're ready for that lawsuit, okay? And a lawsuit can be filed as soon as a denial has been made on your appeal and all of your appeals have been exhausted. At that point in time, you're ready to file the lawsuit, and as you know, because the administrative record basically closes at that point if it's an ERISA case, and if it's not, and you've gone through this appeal process and you've built up the case as well as it could be built up, your claim, and you have all the supportive documentation, then that lawsuit's ready to go.
So for the person that's been denied and they call you up and go, I just got denied and I want to sue them right away, obviously they can't. They got to go through the appeal process before they can, and that's one of the disadvantages of ERISA, although sometimes it can be a positive because often we do win appeals. But for this video, the person's already done their appeal. They're contacting you now and they're saying, look, I did all my appeals. They told me my only remedy is to file a lawsuit. What's next steps do you take?
So what you have to do is, as soon as that denial of your appeals come in, is request a copy of your claim file. Okay, that claim file is critical because that claim file has all of the documents, all of the information that federal court's going to review and consider when you file your briefs, your legal briefs, whether it's your bench trial legal briefs or if it's your motions for summary judgment. It's also going to help you in crafting that lawsuit, or for your lawyer to craft that lawsuit. It's really important because that lawsuit's going to have to contain enough facts for you to be able to state a cause of action for which relief can be granted. Okay, without that level of information in there, information so as to state a claim for which relief can be granted, you don't have a case. Your complaint and your lawsuit will be dismissed, and that's why it's really important to consult with a disability lawyer when you have to file that lawsuit, because no individual could really, I mean, look, our federal court system is constructed such that an individual can bring a lawsuit against any other individual or company. But you really need a trained lawyer to do it, because if that complaint isn't done the way it should be done or is required to be done by the federal courts, it's just going to be dismissed very easily by New York Life.
Well, an ERISA lawsuit is like no other. What's the difference between the typical lawsuit that people see on television and hear about as compared to how an ERISA lawsuit is handled according to the ERISA regulations?
So the big difference here is that you don't have any right to a trial by a jury. Okay, what that means is that you don't have a right to have a jury of your peers, all right, come in for however many days it may take, okay, listen to opening statements, listen to the testimony of witnesses, listening to the closing statements and taking all of that evidence and all of those exhibits that are presented and going back to a jury room to deliberate and review that information. You don't have the benefit of that. What you have under ERISA is the benefit of having a federal judge who's been appointed by the President of the United States, all right, review the legal briefs that are filed by the lawyers and the opposing lawyer, the lawyer for New York Life, to review the responses that are filed by each side, okay, to review the replies that are filed to the responses that each side files, and to review the administrative record, okay, all of those documents that were used by New York Life to make a decision on your claim, okay, and to deny all of those appeals. All right, and also that administrative record contains all of the evidence and all of the information that you've submitted through the course of your appeal and your claim. All right, so they review that information. That's what you have a right to. That's the big difference here in these ERISA cases. They are really like no other, like you said, because in almost every other case, you have this right to a jury trial. In fact, it's a constitutional right in many cases, certainly in the criminal context. You have the right to a jury trial. It's something that's in the Bill of Rights. It's in the Constitution. So you don't have that right here, though, unfortunately.
So, and then some people may say, well, everything I'm hearing so far sounds really good because I'm going to get what is supposedly a fairly intelligent judge appointed by the president, like you said, not an elected official. And that judge is going to determine if I'm disabled. End of story. But that's not the end of the story. Talk about the standard of review the arbitrary and capricious clause in the laws, and why the judge, even if the judge feels that the claimant's disabled, that claimant could still lose the claim.
The standard of review is important. It's basically the standard by which that federal court judge is going to review all of the evidence and all of the information to consider a number of things, right? First, are you disabled? Was New York Life's decision wrong? Okay, that's the first thing that they're going to look at. And then if you have this discretionary standard of review that we touched on earlier, did New York Life abuse its discretion? Did it act unreasonably? If you ask any one of the people that call us who've been denied by New York Life, do you feel that New York Life acted arbitrarily and capriciously? Do you feel like they acted unreasonably in denying your benefits? Every single one of those people, including myself, I could almost assure you, will say, yeah, absolutely they did. Absolutely they acted arbitrarily and capriciously. Absolutely they acted unreasonably. You would think that it is an open and shut case. It is the easiest possible standard that this federal court has, and it could not be further from the truth. If you break it down statistically in these cases where that type of standard of review is applied, 8 or 9 out of 10 of these disability insurance cases that go up before the federal courts on that standard of review are decided in favor of the insurance company and are decided basically in favor of New York Life. That's a very, very lopsided and pretty unjust type of statistic and type of playing field you're on. So it really takes quite a bit to overturn that decision by a federal court if that type of standard of review is being applied. Basically, what the court is doing is that they're putting New York Life in the shoes of the trial court, while the federal court is put in the shoes of an appellate court. Okay? And they won't overturn that decision, even if they determine and find that you're disabled, absent an abuse of discretion.
So, to dumb it down even more, the judge reviews the case and says, I think this person's disabled, and then says, okay, now I move on to the next step. I found he's disabled, but did the insurance company take a reasonable action or reasonable approach to reviewing the claim? But what does the judge use other than his or her personal experience to determine what's reasonable? What does the judge have to rely upon to determine what has...
Well, it's the case precedent. It's this history of case law that's been created behind your case, right? It's the many, many years of decisions that have come down, okay? And when you have this standard of review that's being applied, and that's been applied for many, many years, that's a lot of cases that fall in favor of the insurance company. Don't be fooled. I mean, we still have our cases, and we've still had our many victories, okay? But it just takes a lot. It takes a lot of work and someone and a lawyer who really, really knows what they're doing to get it done.
And the case law, so that people understand, and they can go on our website and read literally thousands of cases, because we summarize almost every case that comes out around the country so that people can understand how the courts are reviewing the facts of these cases and making determinations about what's reasonable and what's not reasonable. But what people need to understand is that the case law is all over the place. I mean, it is crazy. You see the same fact pattern in 10 different federal courts and get 5 opinions the same and 5 completely different. And that's because at the end of the day, there's one human individual making a determination. And in each of the federal courts throughout the country, they've established kind of different precedents for what they think is reasonable versus not reasonable. And it's always changing because the facts are very specific. And I think, that's where it becomes important to have a lawyer who's obviously very good at doing the research on the case law, but also truly having the ability to convey in writing, most importantly, why this particular case is distinguishable from all of the other cases. Because at the end of the day, in this type of law, when it's governed by ERISA, this is like a battle of the writers. This is not the greatest orator you've ever heard. This is a battle of writing. The claimant the judge never even sees the claimant, never even gets to testify, come to court, nothing. And so the case is only as good as it is on paper. in a lot of cases, we get to do the appeal, which is great. And then we can represent the claimant in lawsuit. But in many cases, claimants call us and they had another lawyer or they did the appeal on their own because they didn't necessarily know the importance of having an amazing appeal. And that is what we're stuck with, per se. That's the evidence. That's all we're given. It's like going out to a job site and saying, here's the tools, here's the material. There is nothing else available. You cannot go to Home Depot. You can't call the supplier and say, bring me some more plywood. That's it. We are married to what's there. And that's what we deal with. And it's very challenging, but as much as the statistics are bad, where, like you said, 80% are won by the defense, we've had a lot of success at winning these cases. And that leads me to the last point, Cesar, because really I want to encourage someone to call us if they've been denied to talk about the specifics of their case. But due to the risk of these cases going to a federal judge for a decision, how do most of these cases resolve after a lawsuit's filed?
So, look, 90% of these cases, even with those pretty grim statistics, because I know that after hearing that, someone may think, "Wow, well, my case looks pretty bleak here. I couldn't even get my doctor to complete these forms in support of me. How am I going to win this federal court case now against New York Life?" Even though everything may seem bleak, trust us, there's still the ability to get reasonable value and reach a reasonable compromise, because there's still liability. Okay, there may be a judge that looks through all that, okay, and says, I feel this person is disabled, and I do feel that the actions by New York Life were unreasonable and arbitrary and capricious, and New York Life understands that. So they're willing to come to the table in most cases, sit down, and try to at least reach a compromise and resolve it. And that is how most of these cases do resolve, is through a settlement, through a lump sum settlement. In other words, where there's a complete divorce from New York Life, all right? You agree to accept a sum of money, a settlement, in return, a dismissal of the lawsuit, a release of any and all claims and causes of action that you could have brought against New York Life, or that may be brought against them in the future. You're releasing them of everything, all right? And basically a divorce from them.
So you get a lump sum settlement. The person the next day can go do whatever they want. There's no more risk, and they get a finality in what it is. And the reason for that is that these cases have a finite amount. So if your benefit is $5,000 a month and it's supposed to pay you for 10 years, then it's worth $600,000. So
and Greg, another point, not only can they go do whatever they want, but they don't have to continue to prove their claim to New York Life. A lot of people don't realize that you could go to federal court, you could win your case in federal court, but all that's going to do is get that case remanded back to New York Life, and you're likely going to have to stay married to New York Life, a spouse that you don't want to stay married to, you don't trust, to continue paying your benefits.
Right. So some people like to have the advantage of a settlement, and of course, in undisputed claims, New York Life and Cigna have been doing lump sum settlements for a long time. But look, it's a business decision. When it gets to that point, it's most likely in a settlement never going to be the amount of money that you wanted to get as a claimant. That's the reality of how it is, but it's a certainty. And as the lawyers, we'll give you our advice as to whether or not we think we can win. We're never going to push anyone into a settlement. That's totally up to them. And we've gone the distance plenty of times, and that adds a lot of value to the settlement offers for the claimants, because New York Life respects our firm and knows that we have what it takes to take the case to distance. And that's what's most important if you're a claimant, is to have a lawyer that has been there before, knows what to do, is well respected, and can get you the most value possible out of your claims. So if you've been denied benefits by New York Life and you've already, no matter what, even if you need to file an appeal or you've already filed your appeal, feel free to call Cesar or myself. We're going to provide you with an immediate free consultation. We're going to let you know right away if we can help you. We file these lawsuits all over the country. We have claimants all over the United States. So your location of where you are is not an issue for us, because we can practice these cases in federal court anywhere. We look forward to the opportunity to speak with you, and we'll be here when you need us. Thank you.